Hello, my name is Ali Carter. I'm the Managing Director of Mediate UK, and I'm going to talk to you today about the form C100, which is the form you will need to send to court if you are looking to ask them to sort out the child arrangements for your children. So if you download the form, which you can do from the government website, just Google form C100. You can do it from our site mediateuk.co.uk as well. That's page 3 of the form. I go straight to page 3 because first one is to do with a mediation meeting, which I'll come on to. Second page is blank, so the first one you really want to be paying attention to is page 3, and you can see here under nature of application, I've highlighted the 3 boxes. You'll be ticking one or maybe more of these. So I'll talk to you about those first of all. You can ask for court to make a child arrangement order, and this is going to sort out where your child is going to stay and when, and also what arrangements they're going to have for contact with other people within their family. In a nutshell, that's what you're asking the court to make a decision on. You can make a prohibited steps order. This would be where you don't want something to happen, and that would normally be the case if a child is being removed from the UK or being moved to another area within the UK that you disagree with. And then the third one is a specific issue order, and this would be something around which school the child goes to, or whether the child can go on holiday with a parent. Those would be the sort of general ones for that one. And once you've completed and ticked that, there's under additional information required. So there you go, nicely highlighted there for you. You can ask there if you're applying for an order to be formalised under a consent order. So this is where you can use this form where you have an agreement with the other party, but you want the court to make that into a legally binding agreement. If you want that to be the case, the court will only do that if you can show them and prove to them that it's in the child's best interest to have an order by the court. There is still a no order principle, and there's many reasons behind that. So the page 1 of the court is to confirm that you've attended a mediation information meeting called a MIAM. The majority of the form is then looking at MIAMs and whether you need one and whether you have a reason not to attend one. If you look down below now, you'll see there's a link to the 15 reasons why you don't need to have a MIAM before going to court. But for the majority of people, you will need to attend a mediation assessment meeting, and therefore you need to have page 9 of the C100 completed by a mediator who is authorised to conduct MIAMs. And if you're using a company such as Mediate UK, that's not going to be an issue. You can always check on the Family Mediation Council website as well if you have any concerns there. So you've been to a mediation assessment meeting, you've considered mediation, you still want to go to court, you can complete the rest of the form. That is really around the details of the children, any previous cases where the court has had an issue, a lot around the risk to a child and what sort of order is that you're looking for. So it's relatively straightforward to do. You can do it yourselves, you can use someone with legal knowledge, or you can use a solicitor to complete the form for you. You send it to court and they will check that you've done you've got page 9 signed off, otherwise they'll probably send it back to you and they will put a date in for a hearing. They'll also write to the other party. So why is so much of the form dedicated to mediation meetings and whether you need one and the reasons for not attending one? And this is because so many cases at court could and probably should have been dealt with outside between the parents themselves, and mediation is the preferred way. The court don't want you there in the nicest possible way. They would rather be dealing with cases where there's severe risk to a child, to cases where there is a need for a court with authority to order things, not where a child's going to stay on a Friday or Saturday night, which junction they're going to change over to on the M4 on a Sunday. So where possible, you should be looking to try to mediate this. Even better, try to agree it between yourselves without mediation. But if not, mediation is the next logical step up. and that's why so much of the form is dedicated to that. The other thing to consider is if you do end up going to court, the court will want to see that you've acted reasonably and responsibly. A big part of that is offering mediation, is trying to resolve things outside before you've got to court. If you do those things, it's not going to go against you at court. It's going to look good that you've tried to be reasonable and responsible as well. So the guide below takes you to a page-by-page guide on how to fill out the full C100 form. I've just highlighted to you today 2 of the pages. If you have any questions on this, if you're not sure whether you need to do a mediation assessment meeting, if you're not sure whether court is going to give you the answers to your current situation, then do get in touch with us, mediateuk.co.uk. Give us a call, 0330 999 0959. You can even book in a consultation with us to find the best steps forwards through our website. So I wish you best of luck with resolving the issue around your child arrangements, and thank you for listening to my guide on a C100 form.